Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the Probate Realtor himself, Matias Baker Masucci.
Welcome, everybody, to another one of our episodes. Today, we have a guest coming back, Scott Rahn, which is a very well-known litigator in trust and probate. Scott, welcome back to the show.
Thank you. Thank you again for having me.
Absolutely. Let's get right into it. Today, we're going to be talking about breach of fiduciary duty, what that involves, what it entails, and what better person to discuss this than a litigator. So, Scott, I wanted to start from the basic. In the context of trust and probate, what is fiduciary duty?
Sure. A fiduciary duty is simply a standard that applies to anybody who is managing someone else's affairs. And basically what that duty says is that you have to put the interests of the people for whom you're administering that estate above your own interests. So you have a duty to care for those people above and beyond what you would do, even for yourself.
That makes perfect sense. Now, let me ask you a question. Correct me if I'm wrong, but when you get appointed administrator of an estate, isn't there some documents that kind of briefly explains, is it statutory? There's some document that says what you are supposed to be doing as the administrator of the estate, some kind of training?
Sure. Yeah, there are documents, but there's also the probate code, which is essentially the Bible for anybody who's administering either a probate estate as an administrator or executor or a trust estate as a trustee or a co-trustee. And the probate code is really written for the layman, for everyday people, because so many people administer estates for their own families. Surviving spouses administer estates when their spouses pass. Children administer estates when their parents pass. So it's really intended to be written so that it's easily digestible by everyday people.
Perfect. That makes total sense. You know, there's a philosophical undertone to this. The ability of putting someone else's interests above your own, it's a difficult thing for human beings. I mean, in general, ultimately, through our evolution, we have specific needs and we always think, so it's kind of an elevated point of view, if you will. It makes me think of like some religious approach, like Saint Francis, or like somebody that would say, yes, the care for the people that can no longer speak for themselves and things like that. And in a sense, I guess there's a lot of that in really having the ability to say, okay, what is best for the estate? What is best for the people involved, for all the beneficiaries?
That's exactly right.
This kind of leads me to, let's talk about breach of fiduciary duty. So I guess that would be the reverse. That means like if you are putting your interest ahead of that of the estate, right? Is that in a nutshell what it is?
In a nutshell, but that would be a giant nutshell to cover all the things that are potentially breaches. There are so many different ways that people get themselves into trouble, and in some of them, I think most of them are commonsensical, but some of them I think people have a difficult time with, to pile on to your biblical reference, right? We are a flawed being, right? Humans by nature, we're self-interested, we're self-protectionist, etc. And I think far too often people's self-interest gets in the way of what they're supposed to be doing, which is exercising their diligence to carry out the wishes of the person who passed rather than themselves for the benefit of the people or entities the decedents intended to benefit rather than themselves. So, we really see people getting into trouble often in breach of fiduciary duty cases where they're now appointed, either they're appointed by the court as administrator or executor, or they've assumed the role of successor trustee, and now their ego gets in the way, right? I'm in charge, right? I'm the one who was anointed, right? I'm the one who needs to make these decisions. I'm the one who's going to control the flow of information. I'll give you what I want to give you when I want to give it to you, right? And I think that's really all too often that is an easy way to get off on the wrong foot because ultimately every fiduciary has a duty to communicate with
Right.
their beneficiaries and make sure that people are well informed about the administration, what's going on, what the issues are as they arise, what the proposed handling strategies are. And I think far too often, especially when you have family fiduciaries and you have the one child, either the golden child who doesn't want to bother with all of the other siblings, or you have the ne'er-do-well child who
Mhm.
is afraid that people are going to take things away from them. And then what they do is they clam up and they come at this instead of from a place of vulnerability and candor, they come at it from a place of, I'm in charge, my ego's leading this. And it lends itself to conspiracy theories and wild suspicions about thievery and all these kinds of sorts of bad acts. And once you go down that path, then generally people are going to lawyer up to investigate. And there may
Right.
be some there may not. But when you're not communicating, it lends itself to a lot of these wild fantasies.
That makes perfect sense. Now, I've had people that have been following this show. I had an attorney on this show who was one of the litigators who, back years ago, who made trust accounting that ended up becoming law. So the decision that ended up going to the Supreme Court,
Mhm.
I think it was California Supreme Court, and then ended up making the law. The reason I'm bringing this up is because there are statutory requirements now. So if you and correct me if I'm wrong, because I know that probate and trust administration, there's a little bit of a difference. But if a beneficiary suspects something and they
Mhm.
make a request, now does the administrator or executor have any obligations that are statutory to communicate, or they can say, look, I'm doing a great job. You don't know what you're talking about. Let me take care of this until the end. Or are there requirements where you're like, no, you got to do it. You have to give me this update. You have to tell me that kind of information.
So, a couple different things going on here. One, the duty to communicate doesn't necessarily include a duty to fully account pursuant
Okay.
to the provisions of the probate code.
Okay.
But just because you don't have the obligation to fully account, often it's going to be in your best interest to do so
Right.
because you're providing even more information than you may be required to provide, and it's going to provide you protection. It's
Right.
going to put people on notice of what you're doing, the reasons why you're
Right.
doing it. And if they have any concerns, it's going to start the running of that clock for when they need to file any sort of claim to
Hmm.
challenge what it is you're doing.
Right.
And I think one of the really powerful tools when you're talking about trust administrations is you have the potentiality, as long as it's provided for in the trust document, to shorten the statute of limitations for someone to challenge your accounting
Right.
if if you put in the document that they only have 180 days to
Okay.
challenge that accounting. So if you're accounting regularly and you've got that shortened statute of limitations contained in your document and you put that in your notice when you send the accounting, people have to act within 6 months. And if they don't, then what you did, what you revealed in that accounting is going to be blessed and not challengeable. So,
Right.
it's a really powerful tool. And I think far too many people look at information requests,
Hmm.
accounting requests. I think they look at them the wrong way, like someone's challenging their
Right.
authority. The reality is, I think the better lens is to look at these things and realize that most people are scared, right? They've
Right.
lost somebody they love. They don't know which way is up, right? The tales that we've been told over the past 3 decades of doing this work about the jewels and the Cougarans and the real estate all over the world and just the gobs and gobs of wealth that may or may not exist. So,
Right.
people's expectations are often much more fantastical than the reality of what is actually being administered. But if you're not communicating that, if you're not communicating what your diligence is showing you,
Right.
what the assets are, what the liabilities are. Far too often, and you being a real estate professional, I'm sure you see this with large real estate portfolios, just how levered they are, right?
Yeah, absolutely.
So, someone says, my parents, my grandparents, they had this huge real estate portfolio, right? The reality is that there are probably many, many units, many, many beds, but
Right.
there's also much, much debt that goes
Right.
into that. They levered it to continue to expand their empire, and communicating those things to say, these are the assets, these are the liabilities, this is net, this is really what we're looking at. And we need to
Hmm.
make decisions around what the bottom line is as opposed to the top line. But if you're not taking the time to communicate those things, oftentimes that's where trouble brews.
That makes sense. Let me ask you this. Sometimes we take it a little bit a step back just briefly. You
Mhm.
mentioned, like sometimes ego kicks in, somebody's like, they're coming out, they're reaching, they're asking the question, hey, what's happening here? And somebody's like, yeah, I'm in charge. I was put in charge by the parents or whatever. So I am, I know best kind of a thing. Okay. So
Mhm.
that's one scenario. But what I've seen in real estate, and it's often incompetence. So they say that it's a thankless job to be a successor trustee or be an administrator, and one of the things is that I've encountered over the years selling real estate in trust and probate is that I get to see a lot of these properties, when there's limited authority, they require court confirmation. So it's public knowledge what the property is selling for.
Mhm.
And you can see that maybe the property was never marketed properly, or they got an offer, because the Los Angeles real estate market is very competitive. There's a lot of wholesaler calling probates, calling people who want to put the property, and their value proposition is you don't have to pay for an agent. I mean, this happens to client of mine all the time, right?
Sure.
They say
Yes.
you don't have to pay for an agent, no commission, no nothing. Then they give you the offer, and it's like, okay, so you're saving a 5% or whatever percentage for an agent commission, but your offer is 40% below market value.
Mhm.
So, but unfortunately, a lot of people, they may not know this. Like they may live out of state. They have no idea. They want no headache. The wholesaler says, I will buy it as is with all the properties in it. Don't worry about it. You don't have to clean anything up. In that case, the guy is not evil, or the lady who's in charge. They're just unaware. So that's can a beneficiary that finds this out do something
Mhm.
to stop a piece of real estate for being sold for a fraction of what it's worth?
Sure. The short answer is yes, and
Hmm.
those issues come up all the time. In the context of what we're talking about here today concerning fiduciary duties and their breaches, the fiduciaries have a duty of competence, right? To
Right.
do and know what they're doing and to do a good job in fulfilling that duty as any other reasonable person in the same position would. And
Right.
those duties can be heightened if the person who is in charge of that administration, in charge of selling that property, is a professional.
Yeah.
Oftentimes we'll have real estate professionals who are the surviving spouse or the kids or their lawyers or their accountants, right? And depending on what the situation is here, specifically talking about selling real estate,
Hmm.
you've got a duty to maximize that value for the estate, for its
Right.
beneficiaries and creditors. And if you're hiring an agent or not hiring an agent, that duty that you have to maximize the return is non-delegable, meaning you can hire an agent, right, who
Right.
does a good job, or you can not hire an agent and sells the property for more quickly for 40% under market. Seems like a pretty easy transaction to close. um, but you're going to be at risk as the fiduciary for not having done what a reasonable person would do, and you individually can be surcharged for whatever that delta is. So if you're selling it
Oh,
for
interesting.
40% under market value, you're personally exposed for having sold that property under market value. As a beneficiary, as an heir, you also have the ability, if it's a probate sale, you have the ability to object to the sale
Right.
in probate court. And if it's a trust sale, you have the ability to go to court and seek emergency relief to stop the sale, to say, look, this fiduciary is selling this property for 40% under market, and
Right.
it's going to damage the value of the trust estate, and it's going to be detrimentally harmful to the beneficiaries ultimately.
Yeah.
And the courts will listen to those things. They'll listen to those concerns because ultimately the court wants to maximize the value for the estate.
Yeah, and that's why they have the overbid process and all of those things. I mean, the system
Mhm.
is designed to make sure that, obviously people need to know that there is a sale to be confirmed. That's
Mhm.
another story altogether.
Yeah.
But let's get back on our subject specifically. One of the things that we know in the world of probate is that some people try to do it on their own, in propria persona, propere. And you see those when the filings are. Now, obviously, people can say that are listening to this, well, you have a vested interest, you're an attorney, of course you want people to, but not necessarily, because you're a litigator, so you may prefer people do it on their own, they get sued, and then they come to you to get help. But either way, when, we have, just like for sale by owner, right? People try to sell their own real estate.
Mhm.
I'm sure that for sale by owner is much easier than trying to administer your own probate. So
Yep.
when people go on their own without an attorney, and then they end up getting, in trouble with litigation, and then they come to you, are those cases more difficult?
Generally, yes. What happens is people come to us often to ask for help. We walk them through the process and they decide, well, we made it sound so simple that they're just going to do it
Uh,
themselves. And
yeah,
then they go down that process and then they get themselves in trouble and then they come back. And now instead of doing it right the first time, now we're having to try to fix a problem that could have been avoided from the get-go. So it is more difficult and frankly, it's more costly, right?
right.
Because now you're having to right a wrong instead of just doing things right the first time. That old adage, measure twice, cut once. We try to deploy that, but far too often, because you have so many individuals who are trying to do things improper, trying to manage their family's affairs by themselves, they do get themselves into trouble and they come and we're happy to help them, obviously.
Right,
It would be, to be fair, I would be happy if they were all able to just manage things on their own, right? But the reality is, there are complications, there are family dynamics, there are market
right.
forces, all kinds of things that put people in a situation where it's quite easy to fail. And if you don't have the proper guidance, right,
Hmm.
of a good agent, if you don't have the proper guidance of a good probate lawyer, it's very easy to get yourself into trouble. And the reality is we, like you, we know the market, we know the rules, we know how these
Right,
things are supposed to go, right? And by helping to guide them down the right path, it's much easier to avoid the situations. But even in the situations where something pops up, where you
hmm,
have a sibling or another beneficiary who has an issue with it, because we've managed the situation the right way through the entire process, it's much easier to stand in front of the court and explain to the probate judges, this is what happened, this is why it happened this way, and
hmm.
this is why this is the best, most reasonable outcome for this estate, and you should bless what it is we did. And by far and away,
Oftentimes they do.
they do
Yeah.
exactly.
I
So
found to be I found to be judges I think we're lucky in Los Angeles when it comes to the probate division of the
absolutely.
Superior Court. It's run very well. Let's take it back a little step and let's talk about the signs that somebody who suspects a breach of fiduciary duty, what are usually the common signs, other than, I say, lack of communication? But I guess that's the biggest one. What is and lack of transparency? But what are some of the other things that you've seen in your practice that could be some red flags for people to look out for?
I think some of the biggest red flags are seeing assets being transferred
Okay.
to the fiduciary, assets being transferred to their family members.
Mm,
That is probably one of the most common and biggest red flags, and it's
okay.
it's pretty easy to track, right? You can, pull title on a
Right.
property, right? You have account statements from financial accounts where
Hmm.
you see that, mom or dad had, $1 million, the day before they died, and now 3 months later, the account's empty, right? And
Right.
sometimes it's a mistake, right?
Hmm.
Sometimes these individuals don't know what they're doing and they're just commingling everything into,
Right.
one account for, ease, for their own ease of labor. But sometimes and far too often in our practice, again, only doing, disputes, far too
Right.
often they're taking things that don't belong to them. right?
Right.
And often under the guise of, well, mom or dad said that I should have this, right? Well,
Right.
the document says otherwise, right? The document says you have to split this up between you and all of your siblings, right? Well,
Right.
mom told me on her deathbed that, I should have, the jewels or the art or the house.
Right.
And so those things turn into disputes. I think most often it's somebody who, and it's far too often, the family member that everybody always experienced those same types of scenarios with.
Mm.
Far too often, our clients will come to us and say, my brother or sister, et cetera, has always been like this, right? They've
Right.
always had their hand out. They've always, taken a little bit more, right? They were always the one who was asking, needing, taking. And so this isn't a total surprise. Sometimes it's a surprise, but that's probably one of the biggest red flags. Just keep an
The
eye on the
movement of
assets.
funds, the accounts, yeah, that makes sense. That makes perfect
Mhm.
sense. Okay, let's move on to remedies. This is
Mhm.
now we're starting to get. This is where I'm really fascinated. Okay, so what
Mhm.
are the remedies? We caught the breach of fiduciary duty. Somebody comes to you, says, Scott, my brother just moved $1 million from my mom's account into his own account, and I saw it because I went online. What do we do now?
Sure. I think the first thing you do is obviously gather all of your facts. It's not what you know, it's what you can show the court. And
Right.
you have to remember that, the probate judges sit and hear dozens and dozens of cases every day of
Right.
some of the most heinous things that you could ever imagine family members or non-family members doing to one
Right.
another and doing through these estates. So you really want to make sure that you're crossing your T's, dotting your I's, and what you're putting in front of the court, because you're going to go to the court
Hmm.
and ask them for help, unless you think, and this is where we really lean into our clients, knowing the players who are involved. Is your thieving brother or sister, are they someone who's going to respond to a
Right.
phone call or a letter telling them put it back or else, or
Right.
far too often they're not somebody who's going to respond. So you're going to court, but you want to make sure that what you're putting in front of the court is really going to grab their attention and help them understand that, hey, look, this is a bad person who's done bad things. They've
Hmm.
done it intentionally, and the estate needs protection from them. And you're going to go to court and you're going to ask the court to suspend them, right? Take their powers away,
Right.
freeze the assets potentially, depending on where they are, or order them returned to the estate. The first thing you need to do is stop the bad actor from what they've done and stop them from doing more of it. And once you've secured the estate, then you turn your attention to recovery, damages, and all those kinds of things. So you're going to proceed to seek an order from the court having those assets returned to the estate, whether it's real property, a house, a building, financial accounts, monies.
Right.
And then you have the potentiality to recover your attorney's fees, costs.
Okay.
Depending on how heinous the actions are, you have the potentiality for punitive damages, double damages, because if they're stealing assets from an estate, the probate code expressly allows for you to recover double damages against that person. They come back to the estate, but you get the possibility of recovering double damages, as well as attorney's fees and costs because they're stealing from an estate. And the last piece, which comes into play in very specific cases, is there's always a path as well, potentially, depending on the facts and circumstances, and it's a very specific set of facts and circumstances, that you might be able to prove financial elder abuse. And if
Hmm.
you can prove financial elder abuse, then you also have the potentiality for treble damages, but you also have the potentiality for having them disinherited. So
Okay.
oftentimes when you have a fiduciary who is willing to steal from the estate, if they're willing to steal from you and your siblings, they were probably stealing from the decedent before they passed. So,
Okay.
you really need to dig into what's happened right now, address what's happening right now, preserve the estate, protect the estate, but then you go into the next phase of diligence, which is what else has happened and how long has it been going on and how can we weaponize this to maximize the benefit for our clients. So it's a lot of deep digging,
Yeah,
and frankly, it's a lot of
as
fun. It's a lot of
litigation
fun in
is.
the sense that you're doing
Yeah.
investigation. Yeah.
Yeah, absolutely. That's the core of litigation.
Yes.
I wanted to, so the remedies, other than restitution, you have the removal of the trustee or executor. You could file a
Hmm.
petition to remove and appoint somebody else. Now, in these cases, we know a lot of the times they try, when there's a dispute like that, in order for the judge to be happy and make a decision where they feel comfortable, sometimes they pick professional fiduciary. They're like, look, I'm not asking to be appointed myself. Here's a professional fiduciary who's handled a lot of cases. So that kind of works in the advantage of getting a quick decision to get somebody else appointed rather than
Hmm.
say, oh, my brother did this, so appoint me because I want to be over. Let's talk about the consequences of a breach of fiduciary duty in our context. So correct me if I'm wrong. In probate, there are no jury trials. There's always, apart from like in conservatorship, there's like certain things under conservatorship where you can have a jury trial, but they're mostly the judge makes the decision. Is that correct, Scott? Okay.
That is mostly correct. Yeah, there are some exceptions, but the vast majority of issues are going to be decided by the judge.
Okay. Now, if a breach of fiduciary duty, so when it becomes a criminal matter, it exits probate. Like, is that what happens? Because if it's a criminal matter, then like you have enough proof, then the charges will be brought on by the district attorney or the city attorney. I'm not sure which one would, but does that exit probate court then in that case, and it becomes a criminal matter?
Yeah, there is a lot of confusion around this specific issue. I appreciate you asking the question,
Hmm.
because essentially you have probate court on the one hand, and then you have criminal court on the other. And
Right.
probate is just a division of the civil court. So
Right.
when you have your probate proceedings going on, if you discover that there is wrongdoing that amounts to something that would be chargeable criminally,
Hmm.
one, we as probate litigators, civil lawyers, we don't have the ability to bring charges,
Of course.
right? Only the district attorney has
Right.
the ability to do that. And I think there's a lot of misunderstanding because people will call and say, my brother or sister, so and so did this. They should go
Right.
to jail. I want them to
Right.
go to jail, right? Well, you may be right, but there's nothing we can do about
Of
that.
course.
Other than this, and what we've found over the years is the work that we do on the civil side in doing our diligence and doing our investigation allows us to help the client put together a nice little package with a
Right.
nice little bow that they can then take to whoever the prosecutor is and say, look, this person is a bad actor, right? They've
Hmm.
done all of these things, right? They were abusive to my mom or dad. They stole all this money. They're continuing to
Right.
do it. They should be prosecuted. And here are all the documents substantiating that. It's going to
Right.
be much easier to convince a prosecutor to take a look at that case because you've
Right.
done so much of the work for them already. And we've really refined this over the years. We have a really good friend of the firm who is a former head of the elder abuse division of the San Diego District Attorney's Office, Paul Greenwood,
Okay.
whom you may have heard speak before on these issues.
Hmm.
And we've really worked hard in tandem to work on these issues to be able to put these cases in a place where, if it's appropriate, the DA is going to prosecute. And we've
Right.
had a number of people over the years who have been prosecuted. We've had people who've lost their licenses in various industries because of the
Right.
work that was done. But that's really the extent of our effort, is helping the client put it in a nice place and
Right.
perhaps talking to the DA and helping facilitate that. But that is entirely up to the DA. And
Of course. That makes perfect sense. Now, let me ask you, let's stay on the civil side for a moment.
mhm,
And let's say, that the embezzlement is considerable and the other side is fighting. They also lawyered up and they don't want to give up, or rather they are, you have a strong case. Let's say this caught on the representing the beneficiary, but the other side is also, well off. These are, is a large estate. So because there are no jury trials in probate, generally speaking, does it become a civil case at some point where it exits probate's court and they're entitled to a jury trial for, in this case, it becomes like embezzlement or whatever a civil matter would be. Help me understand this, because I'm a little confused by that. Would they, because right, a person is entitled to a jury by their, to a trial by jury of their peers, but does that apply in probate wrongdoing, or help me out?
So yeah, and again, there's a lot of confusion around this, so I appreciate the question. The long and short of it is that the judge is going to decide the vast majority of this, because while the probate court is a court of general jurisdiction, meaning they can hear all kinds of sorts of disputes, they have exclusive jurisdiction concerning matters pertaining to estates and various claims that are pertinent to the estate. So
Right.
there are exceptions to that, and some of the exceptions, you mentioned one already, is conservatorships, right? If someone's being conserved, they have the right to a jury trial. And then there are some claims that are brought in probate court, financial elder abuse claims, things like that, where you have the right to a jury trial as well because of the implications of those claims. So those claims essentially will be brought, and generally they'll go into the long cause. You can pull a jury there, right? You're generally not pulling a jury pool in most of the departments and most of the courts in California, but you do have that right depending on it. But generally speaking, if you try most of the equitable issues that the probate judge has authority over first, right, you're going to put yourself in a position where whatever is left to be tried to a jury is probably going to be res judicata, right? Because there's already been a determination about, yes, this was stolen, right? Yes, there was bad faith, right? Or no, there wasn't. So you're going to have some judicial findings that you're going to be able to then lever to facilitate a resolution regarding whatever else is left. Now, there are plenty of people who are resistant even to court findings, rulings, judgments. So, putting those people aside, it generally, if you're able to try the equitable issues to the judge, get your judgment there, it can help facilitate a resolution and bring the case to an end more quickly, which we have found, again, doing this now, in our third decade, the one thing most of our clients want is for the case to be over, right?
Right.
They don't want to, as nice as we are, as nice as you are, people come to us to help them with an issue. We help them through that, and they don't want to spend more time with us than they have to. I've learned to not take it personally, and I understand that. And we really craft our strategies for each and every case to try to put people in the best position possible sooner rather than later, because I know they really just want to move on with their lives.
That makes perfect sense. Let's talk about now, in your role as a probate litigator, how far do you take these cases? Do you take them in the rare occasions where they require a jury trial? Is that something you as well would handle, you and your team?
Yes.
Perfect.
Yes, we're trial lawyers first who focus exclusively on probate litigation. So we're trial lawyers. We are in trial frequently, whether it's a bench trial, jury trial, arbitrations. We are built for that.
That makes perfect sense. Now, let me ask you something else. The judicial right to appeal in probate court, how does that work? Let's say, somebody's found, the judge makes a decision. Do they have a right to an appeal? Do they have the right to have a superior court look at the transcript and find reversible error or something of the sort?
It depends on what stage of the proceedings you're in. So if you're in an interim stage of the proceedings, you have the right to seek a writ from the appellate court, which is very difficult and seldom granted. Once your case is over, and this is a very 500,000 foot view of the appellate process, once your case is finished, you do have the right to appeal. And there are appellate cases that come down in the probate context every year. Nick Van Brunt, whom you know from Shepherd Mullen, he and I speak on those cases, many times every year to give everybody the updates on what the appellate courts have found and, new modifications to case law and new guidance from the appellate courts, sometimes the California Supreme Court. So yeah, just like any other civil.
So it becomes just like a civil matter. In the example of, I believe that once there is a decision Of course, you have a right to appeal, but if you don't pay the damages, interest accrues, and I think it's 10% in California. So that is just applies like civil. So if you're not going to give the money back, the $1 million or whatever you stole, and you want to go through the appeal process, you have the risk of I'm sure, and just the same rules apply. You can bond it, all of that stuff, right? Okay,
Correct.
very interesting. I mean, honestly, Scott, I could talk about this for hours. I have such a huge fascination for your profession, what you do, and the good cause that you stand for. But you know what? I got to wrap it up. I've taken up enough of your time. But before I let you go, something that I want to talk about because of your expertise and how you are like myself, probably much more than me. You have a mission as an educator. I mean, you're always out there. You're talking. You're giving talks. If anybody follows you on social media, they can really see how passionate you are about letting people know what's going on and how they can look out for these things. But if they don't get all their answers from all the content that you put out and then I have put out, and they want to genuinely hire you, what's the best way to get in touch with you for a consultation?
Sure. I think the easiest way is just call the office. It's 424-320-9444, or just look us up on the internet, rmolawyers.com, and
Perfect.
we'd be happy to talk with anybody.
And now the internet, and pretty soon on artificial intelligence, they'll tell you all there is to know about Scott.
Indeed.
All right, Scott, it's been such a pleasure. Thank you so much for coming back on the show. And bye, everybody. Thank you for joining us, and we'll see you in the next episode. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020547763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.